Okay. মানে ওপৰত ডেটো আছে তলত বুজিছো Yes, yes.
Lordship, I beg to mention item number 23, Lordship. Kindly pass over the matter for the day only, Lordship. I have taken the consent of the opposite party. TCR is there, Lordship, only for the day only.
Just a minute, I got the wrong list. Hmm. 23.
Yes, sir.
At the request of the learned counsel for the parties, let this matter be listed again in the next week.
Next week.
No, we have to give a date. Huh?
The
Nine-
TCR is available only for the day, Lordship. I have some personal difficulty there, why, Lordship. Next week, any day, Lordship. 19.
Next week, bail hearing, ultimately succeeded case and.
Let's try, Lordship. Charge sheet and that is there, Lordship.
Okay, we'll take it on 18th.
Highly obliged.
May I please the Lordship, my Lord?
Hmm.
I have applied in item 39, my Lord.
Hmm.
CD is not there, my Lord. I'm on interim, my Lord. It may kindly be extended. Date may kindly be fixed, my Lord.
Third, Mr. Zed Ahmed. learned
Succeed
counsel.
submitted one.
Zed Hamad, learned counsel, appearing for the petitioner. The Case-
Succeed submitted one.
charge sheet submitted. What do you want to
Charge sheet
do?
submitted.
What do you want to do?
I inquired about the matter. They said that CD is not.
CD will not come because the charge sheet is.
Interim also to.
Interim is there.
Well, interim is there, he may approach for.
You can go and approach, we'll keep it, we'll keep the interim open till,
Yes, my Lord.
till you appear.
My Lord. That direction may can be.
Learned APP has submitted that the charge sheet in this matter has been submitted. Full stop.
CS number 165/25,
You have to write that
dated
down.
27/11/25.
Slowly. CS number?
165/25,
Hmm.
dated 27/11/25.
Full stop. In that view of the matter, the interim bail granted to the petitioner shall continue till his appearance before the learned trial court.
My Lord. Deep
Full
level.
stop. On his appearance, he shall pay for regular bail before the learned trial court.
Yes. May I please your Lord?
Yes.
Quick mention item regarding item number 29, my Lord. That
29.
It is CBI, my Lord. That
Huh?
will not come on record, my Lord. That may come on record, my Lord.
Lordship, we have filed an objection in item number 29. That
29.
has not come on.
Come on
record.
record, my Lord.
But give us,
We'll give education slip.
give us, it will come up.
Maybe Mr. Lordship, supplementary item number 51, 50, my lord.
Yes.
We have filed additional affidavit, my lord. Started, kindly
Call for it, call for it.
call for my lord. Obligation.
All documents to be called for, you can give directly. There's no difficulty.
May it please, Your
Yes,
Lordship, item 38,
38.
8. my lord.
Yes, sir.
I am planning to take up on Monday or Tuesday. School copy is there, no? I said.
Okay, Monday.
Tuesday, my lord, Tuesday.
Huh?
Tuesday.
After we say Tuesday, it will not become Wednesday.
No, not Tuesday.
Let it be Tuesday.
I am deeply aware.
Tuesday.
Item number 21, scan copy of the TCR was called for, that has not come, my lord.
Huh?
Scan copy of the TCR was called, my lord, that has not come.
Yes, sir, when?
I've verified, my lord.
Maybe after reopening.
After reopening? After reopening, 6th. It is submitted by the learned APP that the scan copy of the TCR is awaited list on the 6th of January 2026.
Meanwhile, my lord, reminder.
Huh?
Meanwhile, my lord, registry may be directed to send the reminder, my lord.
They will do it.
Deep level.
Send reminder for calling for the TCR.
May I please your lordship?
Hmm.
Lordship, I beg to mention item number 34, your lordship. The CD in this matter is not available, your lordship. You have the consent of the other side, your lordship.
34.
Yes, your lordship.
The learned counsel appearing for the GST has submitted that the CD in this matter is awaited, full stop. Let this matter again be listed on.
Lordship, can it be after reviewing
vacation.
After Bihu vacations, yes. Give a date on after Bihu vacation. On 29th of January. 29th of January, interim order shall continue.
Obliged.
Yeah, please, your lordship. I beg to mention item number 18, your lordship.
1/8.
18, may be possible for today, your lordship. I have taken consent from the other side, your lordship.
On a submission made by the learned counsel appearing for the petitioner with the consent of the
Other side.
learned counsel for the respondents, let this matter be listed again on, choose a date.
3 weeks.
Hmm?
Lordship.
Weeks, no, we have to give a date.
Uh,
Tell us a date.
Your lordship. Maybe after vacation, your lordship.
After vacation hole etu chole na. 23rd you want, it's on 22nd of January.
22nd of, your lordship, my senior is gone to Delhi, your lordship, his medical emergency. Due to therefore, your lordship, that may be fixed due to personal difficulties, your lordship.
Sorry,
My senior has gone to Delhi, your lordship.
which matter are we have given?
18, item number 18, your lordship.
We have
After-
given, we have asked it for 22nd of January.
Okay,
You want some other date?
yes, lordship.
When?
After January, your lordship.
After January?
Yes, lordship.
Okay. February, first week of February, 5th of February. Hmm,
In item number 53, we're supposed to file written objection.
ah,
But written objection ready and signed and notarized in the year 2023.
hmm,
I may be allowed to file this objection by today's.
huh. File it.
Lordship, in item number
You
40.
file it today, we are not adjourning the matter. You file it today, put up a slip. They'll call for it. It will be slip kon diye. Matai dibo objection kon. Item 53, he's going to file this thing, call for cried labor. Yes,
Lordship, in item number 42, we have filed an additional affidavit, Lordship.
42. You want to call for it?
Yes, Lordship.
Wait, please, my lords. My lords, I pray to mention item 45. I'm
45.
on interim anticipatory bail, my lord.
Huh?
I'm on interim anticipatory bail. The case diary has not been received today. Some other date, my lord.
Let him confirm. It has been. Item 43,
No, my lord, item 45.
45.
Yes.
Yes, sir.
Well,
Charge sheet submitted.
I'm on interim bail.
We'll allow him to go and appear once the charge is submitted. We'll continue the interim till then, huh?
So correction of,
It has been submitted that the charge sheet has been submitted by charge sheet number
606/25, dated 31/10/25.
25, full stop. In that view of the matter, this anticipatory bail petition is disposed of, keeping the interim protection given to the petitioner alive till his appearance before the learned trial court to face the trial, if any, full stop. On his appearance before the trial court, he shall move an application for regular bail, which shall be considered on its own merits.
also obliged me.
Disposed of, huh?
May it
Yes.
please your lordship, lordship, I beg to mention item number 26.
26.
Also, in this matter, the conducting counsels comes from Kolkata.
Ah.
Today, due to personal difficulties, they couldn't travel in and is unable to appear before your lordship.
Ah,
I'm praying for adjournment of the matter for the.
you have informed the standing counsel CBI?
No, I haven't unfortunately met her. I was.
We will not pass any adverse orders. Kindly inform the other side. We'll fix the date to your convenience.
They
Yeah.
favored.
Item number 49 from the
49.
From the supplementary list.
Hmm.
I have a file and additional affidavit. from the-
May I please, your
Call
lordship,
for it, huh?
I beg to mention for item number 25, lordship.
25, yes.
The conducting counsel is unwell, lordship.
Item,
I have informed the other side, lordship.
item,
25.
Item 26, 25. TCR is here.
Can it be on 6, lordship, 6 January?
It has been submitted on behalf of the learned counsel for the petitioner that he is not in a position to attend the proceedings today. Accordingly, on his prayer, lists this matter again on the 6th of January. 2026. Yes,
Bless, lord.
My lord, may I pray for listing of a fresh motion bail matter, my lord? My lord, I pray for 2 days of unlisted motion. my lord.
2 days.
Today, because my lord, the petitioner is in the hospital, my lord, due to a injury by a gunshot, my lord.
Ah,
So my lord, the critical condition. So my lord, the police is running after him to arrest also, my lord. So some
anticipatory bill,
my lord.
anticipatory.
Anticipatory, my lord. He has not been arrested. He is in the hospital, my lord. I have another bed number and hospital record, my lord. I have annexed. So he is in Excel Care Hospital, Guwahati. So at 2 p.m., my lord, if possible, my lord, only for motion, my lord. I pray, my lord.
Okay. Yes,
Lordship, a fixed matter not in the list, Lordship, can it be on Tuesday, Lordship? BA, obviously.
May I please, your lordship,
Yeah.
lordship, in item number 26, I mentioned for the
Ah.
other side is here.
Hmm.
I've informed them and they have given their consent.
When do you want it?
Any day of Friday in the month of January, because
In the
obstacle
month of
council's convening
January.
day is Friday. Any day on a Friday in the month of January. your lordship.
Nine thirty go pari, 9:30 go pari na, pasta ase. On the 9th of January,
Lordship, 9th of January is not possible for.
then it goes to 30th. We don't have any other Friday in between.
Deeply obliged.
At the prayer of the learned counsel for the petitioner, who is from outstation and is not able to present himself today, lays this matter again on the 30th of January 2026. Ms. So-and-so learned counsel appears for the standing counsel CBI. Yes.
Obliged.
Deeply obliged.
Since we have got a criminal bench today, we will not start with the delivery of the judgment now, or delivery of the order. We'll try if the bench, because to 3:15, I think we have to also rise. If it is possible, we'll deliver it today. If not, then we'll have it on, maybe immediately on the reopening, we'll try to.
Because, my lord, I will, some submission has to be made, my lord, regarding
Ah,
some, my lord, that exhaustively the submission has not been made on the earlier date. Just, my lord, some point is required to be.
whatever is there, we'll
Yes,
only
yes, my-
try if we can finish the list prior to 3
Well,
o'clock.
my-
We'll give you 15 minutes then.
My lord.
If it is not possible today, then we'll have it
My-
fixed in the first week of January.
As per your lordship convenience, my lord.
Ah.
Your lordship may fix on the first week of January, only, my lord, if it's not subject to.
Let us see, let
Other-
us not presume.
No any, my lord, complication,
Huh?
my lord. On the,
Idea time being, Rakidu. We'll keep it for the
My-
time being.
my-
We'll take it up at the end of the list if time permits. Otherwise, we'll fix it on a day on January.
on the last occasion only, he has, my lord, come to written contention that there is an arbitration clause, my lord.
Ah.
26 is not available. That is his only contention.
No, I have
Huh.
other
I have-
conditions. I've submitted by written.
He has submitted his written arguments, you have not.
My lord.
What is holding you back? Why don't you give us something to read and come?
My lord,
It
some-
speeds up the entire process.
my lord, after perusal of some points, so far as the arbitration clause is concerned.
Yes, we had taken up
My-
this matter because we want the criminal bench to be finished.
We'll file, my lord.
File one,
My lord.
yes.
Item 2.
Lordship.
Yes, why the withdrawal, sir?
Lordship, the judgment has been submitted and moreover, the mandatory period is over, Lordship. So that's why the petitioner intend to approach before the trial court.
Not approached till now? No
Not-
petition
no.
pending there?
No application is pending, Lordship.
No application
No
pending?
application pending.
Yes, sir, we allow the withdrawal then. Heard Mr. Swenson, learned counsel appearing for the petitioner, also heard the learned APP. It has been submitted that the charge sheet in this case has been submitted before the trial court, and therefore the petitioner prays for liberty to withdraw this application and approach the trial court, full stop. Specific statement has been made that there is no other bail petition pending as of today, full stop. In view of the above, the liberty sought for is granted. Be it disposed of on withdrawal, allowing the petitioner to approach the trial court. Yes.
I love this, Lordship.
Item 3.
No, section 6 of the POSCO Act, my lord. A notice has to go, my lord.
Ah.
And the case, an investigation, my lord. So some
Heard.
case diary may be called.
Heard Mr. P. Kutuki. The council appearing for the petitioner. Also the letter APP. Matter relates to POXO, you give her, rights under Article 22(1). Due to defects in, submitting the notices under section 47 and 48 of the BNSS, full stop, and Mr. SCKL appears for the respondents. Call for the C.
We will submit the objection along with the documents.
And call for the records, scan copy of the records from the sessions court.
Session code, Amrut Metro, but
Special just sessions.
because one of the co-witnesses is already enlarged on bail on this.
In the meantime, the NCB may also file their response. List again on
On 6th or 7th January.
7th of January.
Not-
আপডেট কৰি থৈ দিব নহলে মই সেইটো কৰিম তাতে আপডেট কৰিলে ইয়াত আপডেট নাহে নেকি আপডেট কৰি থৈ দিব
I think 6 months, POXO matter, notice maybe six,
Ah,
CDB.
But Mr. Swansel on the council. Praying for,
Here, cattle lordship is there, cattle has been seized lordship, but lordship, the Zimma petition also has been filed lordship. Lordship may see page number 25 lordship. The another person lordship. This is Raju Ali lordship. The FIR has been given on 24/11/25 lordship. On
24/11/25, okay.
Yes, lordship. Because on that day lordship, one Baharul Ali has been arrested lordship on that day lordship. But he was Raju Ali, the petitioner has been arrested on lordship 27 lordship. Without and nothing has been found from his possession lordship. And now lordship, Zimma petition also has been filed lordship, but by another person lordship, one Hamid Ali lordship. Will see page number 25 lordship. The Zimma petition lordship, page 25.
Yes, we've seen.
Yes, lordship. Lordship, and the vehicle where the kettles were there, lordship, that also on page number 26 lordship by another person lordship. The Zimma for the vehicle lordship. But Raju Ali, the petitioner is nowhere connected lordship.
My lord, that person who was arrested, he might be the driver along with that truck. Now page 17, my lord, forwarding report. Ground of arrest. As per the statement of the previously arrested accused person Baharul Islam, the below name accused person Raju Ali is identified as the main kingpin involved in cattle smuggling from various parts of the Assam to Meghalaya. That is the
Lordship, the cattle were lordship, Zimma also given by another person only lordship. Cattle were taken Zimma, filed Zimma for by another person lordship. Vehicle Zimma by another person lordship. He is nowhere connected only lordship.
Arrested on 27/11.
Yes, lordship. On that day lordship, nothing has been found from his position lordship.
No, that is what is hurting us. You were nowhere near, yet you have been arrested.
Yes, lordship.
Some link perhaps has been found by the way. You have to call for the CD, na?
my lord, as per the ground number 1 and 2, during interrogation, the accused admitted that he is the principal operator of the entire cattle smuggling nexus, functioning in a cruel and organized manner. My lord, that is clear, my lord.
We'll call for the CD when?
My lord, Gorshuk, my lord, 18th.
18th.
Gorshuk.
He's again surprised. January or December, you have to specify. Had Mr. Swansel praying for bail under 483 in connection with Gorshuk PS case number so-and-so. Petitioner was arrested on 27/11/2025. Call for the CD. List again on 18th
18th December lordship.
December.
Yes, all blessed lordship.
For a PT application lordship. Case registered under POXO Act lordship. He is behind the bar since 5/4/2025.
Commercial quantity.
Commercial quantity, okay. Petition under section 483. In special NDPS case number 43 of 2025 from page 1, huh? Petitioner is in custody since 26/2025. Call for the scan copy of the TCR. List again on, we'll have it on there.
21st.
21st of January 2026.
May I please, your lordship?
Yes.
There should be FIR type copy, page 9, man.
Hmm. Where do you find so much of cattle? Hmm?
My lord, actually what happened, I have no cultural, agricultural field in the concerned area.
Acha.
The allegation is false, my lord. Kindly come to page 15 for a moment, my lord. The
Just a minute.
Oh. Whatever female buffalo lying in serious injured condition, welfare and said accused person during medical.
Where is your forwarding?
forwarding, your lordship will find that original photocopy is page 22, man.
Huh?
Page 22, photocopy. Lordship, kindly for a moment come to page 15, my lord, the sections which have been registered by police. Section 13(1) of the Assam Cattle Preservation Act, this act does not attract at all, my lord.
Why?
No offense covered by this particular section.
What is the section?
Section 13, man. Section 13 says, whoever contravenes any of the provisions contained in this act under section 4, 5, 6, 7, and 8. 4, 5, 6, 7, and 8 says, my lord,
Is it not easier to carry a printout of it when you have to search for it on your mobile?
pardon me, my lord.
You are searching for it on your mobile, are you not? A printout is easier or a page marking is easier?
I'm sorry. my
Other
lord.
people are waiting. You are trying to convince us that the section is not attracted, so we should grant you bail.
My lord, my humble submission is that I'm not insisting bail for today.
Huh?
The matter may kindly be fixed on 19, my lord. Let the case come.
19th would
Right.
be difficult. We'll have it immediately on the reopening. 5th, 6th, whatever you want.
In that event, my lord,
6th of January?
Azo, my lord.
Huh?
Yes. 3 is the opening. date,
We also have
maybe
to
fix
see
on-
our burden, huh?
3 is, open, maybe fix on 5th.
5th.
In that event, I will take another opportunity before the session, judge, my lord. That
What
is
do you
why
want
I'm
to do?
praying, it can be fixed at 19, my lord.
Okay, 19th.
Fine.
Let us
Thank
let-
you.
see if we can call for the city. Okay. Let us see if we can.
Oblige, my lord.
Hmm? Not it.
Wait, please, your lordship.
Yes, sir.
My lord, here, the regular bail application, my lord,
Huh?
although under POSCO, my lord, but here possibly with a difference, my lord.
Huh? The court is of the year 2020. Full stop. The learned counsel for the petitioner has submitted that, given an opportunity, he would be able to place the relevant documents before the court. However, since the vehicle has been found to be involved in the case, he apprehends that he may be arrested before he can approach the court for adducing his evidence as required by the summons. Full stop. The learned APP has submitted that in the bail petition, there is no document to show that the motorcycle had in fact been sold away prior to the date of incident. Full stop.
Annexure 3, your lord.
Huh?
Annexure 3.
Annexure
He
3.
lost an FIR against the showroom, my lord.
Against the
Annexure 3, your lordship.
page?
Page 18, your lordship.
No, this is that.
Here, in
FIR
detail,
now
Most of the learned counsel for the petitioner
now
has
FIR.
submitted that in fact the petitioner has also lodged an FIR on 26/11/2025 before approaching this court regarding the non-transfer of the motorcycle by the
RC.
then buyer, full stop. Having regard to the facts and circumstances of the case, it is hereby directed that that the petitioner shall appear before the whom?
Before
Yes, you want an anticipatory
Lord,
bail when you are being
additional-
summoned for evidence. Are you
additional,
one of the accused?
additional session judge, Dhubri, Your Lordship.
Yes, he.
I will appear, my lord.
Matlab, someone issued, matlab, means he.
Someone issued for what? Where is the summon?
My lord, I have annexed some order sheet, my lord. Order sheet from the trial court. Page 17 is the last order. Page 17, my lord. Issue fresh summon to the accused person. fixing
Accused,
bail.
he is an accused, he absconding. matlab.
He's been made. Your Lordship.
What is your name?
Shahad Ali Mondol.
Eh?
Shahad Ali Mondol.
Page 16 it is mentioned, matlab.
Ah,
Oh,
so
no.
he is one of the accused.
Yes, he is definitely accused.
He has been made accused. Your
Because that motorcycle, matlab, is registered in his name. From the motorcycle it is seized. Maybe driving by some other person, but he is the owner, so he is one of the accused, matlab.
What if there was an actual sale, you balance the equities, if there was an actual sale, this man will be harassed. for
Yes,
nothing.
otherwise, matlab, but
So he'll appear before the special judge,
My lord.
Gauripur, special judge,
Dhubri.
NDPS Dhubri. Honor before,
My lord, within 15
when is
days,
the
my
next date? 8/12 is gone.
My lord,
When is the next date?
next date, I do not have. My lord, within 15 days, I will appear, my lord.
Now, within 15 days from the date of this order,
My lord.
stop. On his appearance before the said trial court, he shall file an appropriate application for bail
application with all these documents.
with all necessary documents in support thereof, full stop. The learned trial court shall consider the said application for bail on its own merits, full stop. It is provided that if in the meantime, before his appearance before the learned trial court, he is apprehended or arrested, he shall be released on bail of rupees so and so, which bail shall expire on the 15th day from today, allowing the petitioner to appear before the learned trial court.
Much obliged,
Within these 15 days, you will not be arrested.
my lord.
You fail on the 15th day,
Maybe arrest. Obliged, Your Lordship.
we are recalling the bill. Yes, next, dispose of. We are disposing it of.
This,
Huh?
dispose.
Yes, sir.
POXO AB, my lord, notice will go, my lord, to the.
There is a limit.
Yes, sir.
Yes, call for the CD. Heard Mr. So-and-so learned counsel appearing for the petitioner, also learned APP, paying for anticipated pre-arrest bail in connection with so-and-so case number. Call for the updated case diary. Huh?
This statement may be one opportunity to record his.
This kind of mischief, making people eat what they say they are
Eight.
not supposed to. Yes,
8,
8.
Obliged.
এইখন থাকি গ'ল সেইখন সেইটো কেছৰ কৌস্তভ আৰু চৌধুৰী আছিল যে কৌস্তভ আৰু চৌধুৰী আছিল যে সেইটো কৌস্তভ আৰু চৌধুৰী eighth of January.
Supplementary item 50. Okay, in this case, I have filed on affidavit and to the morning I mentioned, parachute does not take. Only look at 2 PM. I will try to.
We have it, yes.
Yes.
Yes, you
Lordship,
had
on
missed out
that-
certain dates.
Yes, Lordship, on the 3 occasions, though it was represented by the youngest counsel.
Mm.
If not, Lordship will fully not disobeying the court's order, Lordship. He is represented for the learned advocates, Lordship, because his apprehension, he could not be
Hmm?
here. Because of Lordship, this is a non-bailable section,
Hmm.
so he might be put in behind the bar, so he
Hmm.
could not physically appear, but he is represented by the youngest counsel. Because the learned court below.
Now if he appears,
Yes, Lord, he will ready to.
still remains a non-bailable section.
That is
Why
why
is the
Lordship-
fear not there now?
Lordship, that is why before this one.
12/11, what is the next date? After 12/11?
Yes, Lordship, 12/11, Lordship,
After 12/11, what is the next
yes,
date?
Lordship, I am not aware.
Have your instructions. What is the next date?
Lordship,
What is the next date, sir, in the matter? You don't know. Last date was 12/11.
yes.
Please find out what is the next date.
কেতিয়া next date কেতিয়া? গমেই পাই।
Mr. Parasar, will allow him to appear on a certain date.
My lord,
During the investigation, where were you?
Lordship, we are never charged, we are shown as absconding. Lordship.
Huh?
We have been, as per my instruction, the petitioners have never been charged by the police, and charge sheet has been late showing them as absconders.
You are the persons who were involved.
yeah, he is absconding since last.
Yes, whom are you appearing for? What do you have to say? They are husband and wife. Now,
Lordship,
Ma'am.
from the FIR itself says,
This is a application for transfer of the case from that court to nearby any court.
why?
Because, my lord, there are some problem is there, my lord.
What problem?
First problem is, my lord, the accused number 2, my lord, in the case, my lord, respondent number 2 is influential person, my lord. Because of him, my lord, PP is supporting him.
Huh?
PP and additional PP is supporting him.
We'll have other PPs and APPs appointed there.
Right. Yeah, your lordship, my lord.
Take up
I
your
will say,
matter.
Because
don't
I
have-
want to point out that petitioner is a lady, widow lady, my lord, 66-year-old. Her husband expired in 2000. Her only son committed suicide in 2016, my lord.
Hmm.
Then she filed an FIR alleging that one agreement was signed
Hmm.
by the accused number 2 and 3, my lord, present respondent number 2 and 3, regarding sale of land.
Hmm.
And within signing on the 3 days, my lord, the person committed suicide. And second thing, my lord, copy of the agreement was not supplied to the deceased. Then she filed an FIR. FIR with some delays there, my lord, because of ceremonial functions, my lord. Then, my lord, when the bail petition was filed, my lord, before the trial court, my lord, PP has considered to the something which were out of record, my lord. May I point out to your lordship, page, my lord, 24. And
At this stage, we can issue notice.
one only thing, my lord, next date is fixed, my lord, 15th, my lord. So only I pray that only for the tin returnable that matter may be stayed. That is
Who is, this lady is the informant,
my, lord.
huh?
Yes, my lord.
Why does she want a stay of the trial?
Because of some problem is there, my lord. I can point out to your lordship how PP is supporting the case, man. She filed an application, my lord, to assist the court, to assist the PP, but that was not allowed, my lord. On the ground that additional PP objected to that, my lord. Your lordship find that what submission has been made, my lord, learned PP, my lord. At the time of granting bail, my lord, anticipatory bail. Page, my lord, 24,
Huh?
page 24,
Huh?
last paragraph, my lord. Per contra learned public prosecutor submitted that according to the case diary, the FIR was filed by the complainant only after 25 days from the date of decease. Since the FIR was filed after 25 days, so there was no postmortem report, but record says on the case diary shows that postmortem was done, my lord. On the dead body.
Yes,
There-
a case of suicide.
My lord,
There has to be a postmortem
my
report.
lord. And my, he has,
What kind of submission the PP has made?
and other things are there, my lord. Difficult to know how.
Just a minute, let us go one by one.
My lord.
Too fast a train. Yes.
Lordship, how he has made that submission, Lordship?
Huh? And that is why they got bail.
My lord.
He has raised no objection if he is allowed to go on pre-arrest bail.
In that case, they can come for cancellation of bail also, Lordship.
They did not come.
Well, I come to know that lady, my lord.
Read the next page, you'll be more shocked. Besides, there is evidence that the accused had been suffering from illness just
Out-
before death.
Out of record, my lord.
Accused is suffering from illness before death, or the victim,
Victim.
or the deceased. How come the word accused?
Accused lordship. He was taken treatment. This is the submission of the PB.
I think he is correct.
But lordship, seeking, yes, he is correct, lordship. That may be transferred to any other court. That I am
Ah.
not going to.
Huh.
Lordship would decide, lordship. But lordship, seeking that informant seeking stay only on that ground, lordship. Whether it is required.
No,
must be
tomorrow,
stay required or not, lordship.
if before notices are served, this PP and we would not like to say the
Whatever.
person who writes the deceased as the accused. If these persons, they work to bring it to a logical conclusion, no illogical conclusion, it will be devastating.
Next day কি হবে না?
Huh?
কি হবে না?
Next date to sir, only as a for argument on another petition filed by the accused for exemption of his appearance, my lord.
See,
Then
he's taking all kind of advantages.
That's why. my
And
lord,
unfortunately, if you look at the memo of party, you'll understand why this is happening. Have you looked at the memo of the parties? Have a look at the respondent number 2.
Not only that, my lord, case remains pending in the lower court for 3 years without any step, my lord, without anything, after filing of the charge sheet.
Do you understand why it is happening?
And thereafter, my lord, 2 years, 3 months to search the summon on the accused, my lord. That's why I appointed to your lordship. 9 years has already been elapsed, but nothing was done till today.
Lordship.
That's why only I pray.
Other circumstances, we would not have
Lordship.
raised eyebrows, but here,
That
Only
kind
I
of
pray-
submission, lordship, and
Because I want early disposal, my lord. I do not want to keep it pending here, my lord. I want early disposal, my lord. Only I need till returnable date, my lord. As your lordship.
I think we have to we have to send it to the concerned
My presiding officer has passed the order, my lord. That is the other.
superior authority also. This order where at page 26, he again records the same thing. He overlooks the entire fact that this is a suicidal death. That there has to be a post-mortem report.
some kind of observation is required, lordship, because otherwise it will happen like on, and it will go on like.
I want.
And
only-
even some message
I
should go also.
also want that case be disposed of early, not to be kept pending. So till returnable date, but I only pray for lordship.
Yes, take done. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned counsel appearing for the, learned counsel appearing for the status APP. Full this transfer petition criminal has been preferred by the petitioner for transfer of the case number, sessions case number
74.
72.
of 2020.
72.
Oh, my.
72 of 2024 pending before the additional session judge within bracket fast track court Sunitpur at Tejpur to any other sessions court of the nearby area, either to the sessions judge Nagaon or sessions judge Dorong at Mongoldoy or any other sessions court. Full stop. The petitioner, the learned counsel for the petitioner, by drawing attention of this court to the documents annexed with the petition, has submitted that there appears to be an apparent injustice being perpetrated in this case, in as much as the respondent number 2 and 3, who are arrayed as accused,
Fine.
number 1 and 2.
1.
1 and 2 in the aforesaid case were allowed to go on bail by the order dated 4/10, by the order dated
4/10/2016
4/10/2016
in CM criminal miscases
in criminal miscase number 620 of
620 and
2016
625.
on
And
wrong,
two cases are there, madam, 620 and 625.
So
Two
the-
cases are both same order pass, same type order pass.
and criminal case number so and so
62 and
six-
62, 625.
620 of 2016 and 625 of 2016. Full stop. 6/1/2020. Full stop. The learned counsel for the petitioner submitted that though the son of the petitioner had met his demise by under unnatural circumstances, comma, which was reported as suicidal death, comma. In the order dated 4/10/2016, it would be apparent that these were bails were anticipated, but apparently the privilege of pre-arrest bail was granted to the two accused on a submission made by the then PP that no postmortem had been conducted on the mortal remains of the deceased son of the petitioner, full stop. In the said order, the learned session judge, the session judge had also recorded
My-
that, you'll give this in the inverted commas, huh? The accused has been suffering from many
Well,
illness just
This
before.
is, madam, I think that this is typical mistake. Madam. It should be deceased. That
You
I,
are signing a bail order.
madam, I am filing a better man.
So when a bail order is being signed, what is the care to be taken? The accused has been suffering from many illnesses just before death. Full stop. The learned PP had raised no objection if the accused was allowed to go on pre-arrest bail. Full stop. While considering the case diary in the aforesaid orders, the learned session judge has also recorded that it is a fact that no postmortem was done on the dead body of the deceased, and so it cannot be understood how the deceased was died. Full stop. And what other things have happened?
My lord, second order is there, madam.
The case records were received
And then I want to take your lordship to page 55.
What happened in page 55?
That is the instant order, my lord. Petitioner filed an application for helping the PP, my lord, by engaging a counsel to help the PP, my lord. That also was objected by the additional PP, my lord. Last line, my lord. Moreover, the learned essential PP has submitted that the ground taken by the petitioner for seeking leave under section 301 CRPC is not sufficient. PP is objecting. That's why, my lord, I came before lordship, my lord.
The learned counsel for the petitioner has therefore
Subsequently, the case
submitted.
has been transferred to additional sessions as FTC, no?
There is also same thing.
Subsequently, earlier it was a session judge, subsequently page 52.
No,
to
that
submit
that is the first order we have just discussed by the session judge. Now, by this order of 16/9/2025,
lordship.
it is before the additional session judge
My
only.
lord, he passed the order,
It is before the additional session judge
my
only.
lord.
FTC,
55.
55.
page 55 to.
50 to Kobe as well.
Same thing is there.
The learned counsel for the petitioner has submitted that the petitioner herein had filed a petition for allowing her counsel to assist the prosecution. However, it was an objection by the learned APP that yes, what do you say about this? The person who wants to assist the PP, he is a listed witness, so witness will now attest.
That is, I am not on that point, but the ground chart by the learned APP, I am on that. Because of the influence of the respondent number 2, my lord, the petitioner did not get any counsel to engage.
No, you suggested a counsel, that counsel was
No,
rejected.
first, my lord, that is also there, my lord. Second ground is there, because of the influence of the second accused, my lord, second respondent here, my lord, petitioner did not get any counsel to assist.
Yes, take them. Yes, what were you writing? On the, because of the objection taken by the learned APP, comma, the prayer made by the petitioner to assist the learned APP was rejected. Stop. He has therefore prayed, submitted that there is a probability that the petitioner and that the case may not receive the proper attention as he has expressed certain, as the petitioner is under an apprehension that the respondent number 2 and 3 have influenced the
Only two,
conduct of the trial.
Respondent 2 only.
Respondent number 2 has influenced the conduct of the trial, full stop. He accordingly prays that the case requires to be transferred to some other court for the ends of justice, other court of competent jurisdiction for the ends of justice. Learned APP has appeared for the state, full stop. On an issue notice, learned APP appears for the state. Extra copies be served upon him within a period of 3 working days. Issue notice to the respondent number 2 and 3 by speed post. Steps within a period of 7 days.
By Monday, ma'am.
Huh?
By Monday, I will take.
Within a period of 7 days, full stop. Since it has been submitted that the case is now listed on
To be listed
15,
on
12,
15th, ma'am.
15/12/2025, comma. This court finds it deems it fit to restrain further proceedings in the aforesaid matter till the next returnable date. Further orders shall be passed on the next date of listing
Right.
upon appearance of the respondent number 2 and 3. Full stop. List this matter again on
May I pray that 1920? Is it,
of
January? Because between there is a holiday, matter. 19 to 22, any date, ma'am.
21st of January 2026. Yes.
My lord, second is, my lord, connected item, my lord. In this case, only notice be issued, my lord. My lord, last impugn order has been challenged here, my lord.
Which is the last input?
My lord, 69.
Get order, Lord.
That I already pointed out to your.
Acha, heard Mr. Maheshwari say, he
Notice be issued.
learned APP appears, issue notice, extra copies, 3 working days, steps on the respondent number 2 and 3 within 7 working
Fine.
days, list again on 21st of January
Fine.
2026.
Both the cases, maybe another. Much obliged.
For addition, item 90.
90. Yes, sir.
Number 19.
The KJ was called from Paris, it is not there.
Lordship, here in this case, TCR was called for. TCR we have received, but Lordship, it is
Yes, there was call for.
completely illegible. We can't read.
Hmm.
We tried it, but we couldn't read it.
The learned APP, heard Mr. So-and-so learned council. Anything urgent today to be done?
No, there's an interim order.
There's an interim. We discontinue it.
No.
We continue.
It has to be continued.
The heard Mr. S. Watago learned council appearing for the petitioner also heard the learned APP. The learned APP has submitted that although the case, the TCR has been, scan copy of the TCR has been received,
I
it
said.
is
I
totally
said.
illegible. And therefore, he may be allowed the opportunity to procure the,
Lordship, registry will call for
therefore,
legible copy. Case
the
diary.
registry be directed to call for the
Legible case diary.
legible copy of the case diary. Full stop. List this matter again on
Last week of January.
first week of February.
February.
No.
Wow.
On 6 minute.
On 6th of February 2026,
The interim.
along with this scan
Legible
copy
scan
of the
copy.
interim order passed earlier shall continue till the next date of listing.
Legible scan copy. Lordship. Scan.
Yes, it's legible. Did I not say legible? Registry to call for the legible, for a legible copy of the case diary.
Item 20.
Hmm.
FC. By the way.
Yeah. Lordship, in this case, Lordship, some area is there, Lordship. Some area is there, Lordship.
Some?
Area payment is there, Lordship.
Ha.
Lordship.
So by when will you complete it?
Lordship, he will pay, the next date in the executive code is on 5th of January, Lordship.
Hmm.
He will pay entire. Lordship.
He will pay
The entire area.
during the execution.
No, now, in this case, Lordship, execution, so it is.
On last
they are-
occasion, your lordship fixed today for clear the area amount and your lordship wanted to dispose it up today, lordship.
Yes.
As Rajnish versus Neha was not
Ha.
by the court.
Lordship,
You want a delay in that? We
No,
are
no,
vacating
no,
any stay.
But lordship,
We are
I had
vacating the
taken
stay.
instruction
I'm
from
making-
them that they said that in DB case, he filed his assets and liabilities as she was lordship not working at that relevant point of time. She was not required to file assets and liabilities. Rajnish Barsa, Neha says if labor, they may be exempted, lordship. So at that relevant point of time, she was not doing anything.
If
lordship.
labor,
Yes,
she
lordship.
is not a labor, she was not even labor also.
She is not doing anything, so she
You
was
made a
not.
statement that I am not working.
Yes, lordship. That
Was the
is-
statement made?
Lordship,
It
and
is-
she
my
has
learned friend
opted-
is saying regarding DB case. Yeah, Lordship, I am not for DB case, Lordship. I am
no, I'm
for
just
the maintenance
pointing
case,
out that-
Lordship, filed in the family court. Lordship.
Hmm.
My learned friend is saying the DB case.
No, you were supposed to clear up the dues by today.
Lordship,
Lordship.
what happened, Lordship? Because of not my fault, Lordship, the area amount was that. Because as per the order, Lordship, order was passed on 2nd of December 2014. I have submitted application along with about 10,000 on 7 January 25. This was not expected. Secondly, Lordship, I was said that the date was fixed on 27. Accordingly, I have filed, submitted, Lordship. But they have not received, Lordship. Kindly see the additional affidavit filed by them, where an order of the executive court is there. Kindly check. Page 92, additional affidavit filed them, filed by them. 92. How the area was, kindly check. Page 92. When I filed Lordship on 27/1, then they took time for filing Lordship objection. Then they filed objection. Thereafter, objection and my petition was heard. Then an order was passed allowing me to submit on 7th of April, Lordship. In the meantime, the amount was, Lordship, became aerial. Accordingly, Lordship, petitioner filed, submitted.
No, you are required to pay 50% of the maintenance allowance by the second party with effect from 2/12/2024.
Yeah.
What is the total amount till today?
1,20,000.
1,20,000. What have you paid?
40.
Paid 50,000. This is the receipt.
Maybe 10,000 paid recently. but
50,000.
50,000.
As per my information, till today, 80,000 is the area amount. And my learned friend is pointing out to the additional affidavit I have filed, annexing the last order. And thereafter, Lordship, another order was passed on 23/7/2025.
Hmm.
There is a clear direction by the court that first party is present, second party is absent. Advocate Kishan Hajarika Bhait petition number so-and-so has deposited rupees 10,000.
Yes.
Only toward maintenance allowance, which is duly received by the first party. Second party is directed to pay the area current maintenance along with the remaining area as directed by the Honorable Guwahati High Court, Guwahati.
Yes, sir.
Yes, we are vacating the stay.
No, no.
You go and you pay.
Kindly, Lordship, because of their objection, Lordship, some area was, thereafter, Lordship, I have regularly paid, receipt is there, Lordship.
Huh?
That order passed in the month of July, Lordship.
Lordship,
July, August, no
Okay.
payment is made today.
Lordship,
June,
and
payment made.
last day.
July payment made.
20,000, Lordship, he paid, Lord. And
Huh?
November or December, he will be paid. Next date is fixed, Lordship, on 5th of January, he will pay, Lordship. Because before date, they are not accepting nothing. On the date, fixed date, Lordship,
39663.
you have to,
Is this, why are you, 23/7, 23/6, 23/7,
23/7.
then
Order passed.
23/5? What about September, July, August and September?
Lordship, on 10th, Lordship, he has paid again 20,000.
Yes, 1 month still missing.
Missing, Lordship. He will pay everything, Lordship, on 5th of January. The date is fixed here, Lordship.
You will pay on
Pay,
5th of
Lordship.
January.
Yes, sir.
Pay and come back.
Lordship.
No other way. You pay and come back. You pay up till January
Yes,
then.
sir. He will pay.
Is it not?
Yes, sir.
Learned Counsel appearing for the petitioners has submitted that though efforts were made to have, to pay the arrear amount, comma, the said payment would be completed on the 5th of January 2026 when the matter is listed before the Learned
Executive
Family Court.
Family court.
Learned Family Court, full stop. List this matter again on 9th of January 2026.
Part-time, Lord.
Eh?
Part-time, Lord.
Lordship, may I pray one thing? In this matter, no notice was issued as I have appeared by filing Wakalat Labal.
Ah.
Lordship may issue notice and call for the scanned copy of the record, Lordship, by
No, if-
9th of
if-
January, Lordship.
What we proposed to do was if the payment is made up to date to you,
Lordship.
since he did not have the opportunity to file his
WL.
WS, we are not on the WS at all.
Lordship, my.
Only to the extent that what
Assets and
is his
liabilities.
assets and liabilities he will place before the court, the
Lordship,
matter will be reconsidered by the family court in accordance with the records before it.
Lordship, I have.
No other
inform-
escape for him.
Lordship, I have information that, Lordship, he has filed his assets and liabilities before the DB court. So I have obtained the certified copy and submitted before the family.
Use
court
it
in
against
month-
him, use it against him in the maintenance case. If he tries to differ from that,
Lordship,
use it against him.
So we have submitted the certified copy of assets and liabilities from the DB case in the maintenance case.
Huh.
Thereafter, order was passed, Lordship.
Could be,
Lordship,
could be, but he has to have an opportunity of placing that document. If the document is the same,
Lordship.
all that the family court requires to do is say, it is the same document, no difference in the judgment.
For me, it will be.
Your
better-
interim continues, it does not stop,
Yes.
it does not
Lordship.
stop.
Lordship,
Whatever is the interim does not stop. Maintenance he has to pay.
Lordship,
Interim will continue till the family court comes to a final decision.
Finally.
Lordship. Then he may clear the area amount on
On
5th of
5th,
January.
on
and-
9th, we are having the matter.
Yes.
And he will obtain the certified copy and produce this before this court, Lordship,
What, sorry, by the way?
Certificate copy
Or-
of what?
that he has cleared the area
I
amount,
will pay
Lordship.
with the receipt.
He'll give us the receipt. He was giving us receipt. He'll
Lordship.
give the receipt. What did we say? Last sentence? Place this matter again on the 9th of January 2026. Huh? The learned counsel for the petitioner shall on that day submit the receipt of clearance of all maintenance, all dues of maintenance required by this, as directed by this court. Full stop. Yes,
Obliged.
I do need a break.
Item 53. My lord, they have filed an affidavit. At least something worked out, my lord. After this got listed, they were supposed to file this affidavit within 2 weeks. In the meantime, 2 years has done by. So
Morning, I made.
my
yeah,
actually
before.
has at least worked out something for me. At least they have filed an affidavit. So my lord, let it come up after the vacation, my lord, no issue. I'll
First
take
week of February.
my lord.
When have you filed it? Today.
Today, my lord.
Today.
Today, fine.
Pursuant to the order dated 7/6/2023, the respondents have filed their objection today. Full stop. Place this matter again on 3rd of February 2026. Eh?
Third week of February.
My-
No,
we-
3rd of February,
Yes, my
That's-
lord. So we
Not
have
week.
urgency, my lord.
not week, huh?
We have urgency, my lord. So my third,
3rd of February
February.
2026. Allowing Mr. R.
Third of February, we have some outstation matter.
so my lord can prepone it.
After third.
4th of February?
My lord.
4th of
Yes.
February 2026, Mr. Ardhar may on so and so, yes, हो जाएगा. Any interim there? No.
No, there is no interest. It is for cancellation of bail, man. Bail hearing, item 22.
Yes.
May I please, Your Lordship? Lordship, that day I prayed for withdrawal.
Oh, yes.
My lord, that case I have searched in the my lord, website regarding Moirabari PS case number, 2 case was there. One is bail petition 81/25 that was disposed of 25/3/25 bail. Subsequent to that, this bail petition filed. But that trial court case, that is POXO case number 54/25, that is still going.
Petition being filed by him. Full stop. The petitioner, the order releasing the petition on bail was passed on 15/11/2025, which is apparently during the pendency of the present bail application. Full stop. There are specific instructions, notifications, and requirements that the pendency of a bail petition has to be declared before all courts where subsequent bail petitions are filed. The pendency or culmination of other bail petitions have to be declared when subsequent bail petitions are filed before competent court of law. In the present case, we find that during the pendency of this bail petition, another bail petition had been filed before the learned trial court. Full stop. It is the information as to whether the trial court had been informed regarding the pendency of this bail petition is not before the court today. Full stop. Without keeping the matter pending, this bail application is dismissed. Full stop. A copy of this order be transmitted to the
Learned, special just POXO.
to the learned special
Special
judge
Judge Pokto,
Pokto,
Morigaon.
Morigaon. for him to cause an inquiry as to whether in the bail petition filed by the petitioner before the said trial court, comma, the disclosure of this pendency of this bail petition had been made, and if not made, to take appropriate action. Full stop.
Bail petition in connection with, Malad, may mention specifically,
Ah,
POXO
the
case
bail
number
petition-
54/25.
the bail petition,
In connection with POXO case number
so case number
54/2025,
54 of 2025.
arising out of Moirabari PS case number 39/2025.
एक गुटे to DD करो ना. Stop. Bail application accordingly dismissed. It's only because two different courts and pendency has been done.
Had, Malad,
The
if,
charge sheet part, we had overlooked that day, otherwise. Yes.
Item 24.
May I please, Your Lordship? Lordship, commercial quantity, although it
Hmm.
was commercial quantity, today, Lordship, scanned copy of TCR is awaited. Lordship, there is a backdrop of the matter, the TCR, how it will come, Lordship, the charge sheet filed before the session court is a defective charge sheet filed by the IO. It is filed without FSL. And on receipt of the defective charge sheet, the same was returned by the learned session.
Hmm.
How we will wait for, and it is already 5th to 6th date.
Yes, tell
More
us
than
that.
2 months. More than
Filing of a defective charge
than
sheet
2 months
without the
filing.
FSL.
We have already received the information that charge sheet submitted. Or communicated message, the message is
The
there.
backdrop, we
So-
have inquired in the session court, Lordship. Their matter is that a defective charge sheet was filed.
Do you have the copy of the order?
Order, I do not have copy. Lordship, I have on the register, I have seen an entry. While inquiring, I came to know that in the register. there
Who
is-
sends it back? Once a charge sheet is submitted, who sends
Session,
it back?
Session.
Huh?
Session.
There must be an order somewhere.
Yes.
Get us the order on the next week.
No,
Get us that order on the next week. We'll do what is necessary.
Lordship.
Huh?
Lordship.
Today is a Friday. When do you want it?
And
Wednesday?
last 2 months, Lordship, this matter is.
No,
been
Wednesday.
rotating.
Now since they are not discharging, now they are not being able to discharge, as you say. We let you discharge. Tell us, Wednesday,
Wednesday.
to
Lordship,
your interest.
Lordship, Lordship. Deeply.
The learned counsel for the petitioner has submitted that the charge sheet filed before, charge sheet file in this present case had been returned as it was a defective charge sheet, full stop. And therefore, comma, and therefore the scan copy of the TCR has not been made available before this court till today, full stop. The learned counsel for the petitioner is given the liberty to produce certified copies of orders returning the charge sheet as stated by him. On? Huh? Who sorted it? It will know.
17th.
Sorry, 17th, yes. 17th of December 2002. 17th of December.
Deep. Sleep.
Yes, sir.
As per, may I please?
Hmm.
As per office to take a 9/12/25 services awaited in this case. let's see. So we have to take.
27/11/25 fresh steps were required to be taken.
My lord, we have taken all the.
Then on 12/12. There is no service report.
Twice or thrice we have taken steps, my lord. Most probably, my lord, two times we have already taken steps.
On 12/12, we had,
And then earlier occasions also we have taken steps, my lord.
no, did you take it after the order dated 27/11?
For fresh steps.
Yes, my lord.
What is the allegation?
Allegation, my lord,
Also
already, my
for-
lord. FOXO, my lord, 4, my lord. Main section is there.
But it was a 90-day period of it.
Oh.
So CBI went to apex court, my lord.
Huh.
Apex court said, you surrender because default bail could not have been granted at that
Granted.
point of time, my lord.
Ah.
So it came back.
Hmm.
Now, my lord, there are 2 points to be decided, my lord, with all respect, my lord.
Hmm.
Apart from charge seated, my lord, are that to my lord, partial charge seat, my lord. So that, my lord, Ritu Savaria will prevail, my lord.
Hmm.
And Ritu Savaria was challenged, my lord.
Hmm.
CBI challenged it,
Hmm.
and apex court said, my lord, that it is good law.
Hmm.
Meaning thereby any charge sheet submitted, with all respect, my lord, where further
If it is a
investigation
part
is,
charge.
further investigation is continuing.
Hmm.
Earlier 173.8, now 193.9, my lord.
Hmm.
Would be a day then, so far as the prosecution is concerned, my lord. So default will prevail.
Hmm.
And secondly, my lord, with all respect, my lord, earlier bail applications prior to bail being granted by the Guwahati High Court
Ah.
on the ground of default wrongly, my lord.
Ah.
That's a different matter,
That
my
is,
lord.
ah.
Prior to that, applications were filed before the, my lord, special judge,
Hmm.
meaning they are by the session judge of the endemic district, my
Hmm.
lord. Their bail applications were rejected on merit, my lord.
Hmm.
There, my lord, that violation of 47-48 were
Not
never
fair.
taken into consideration. Although, my lord, the learned magistrate initially said that 47-48 complied with.
Hmm.
And regarding compliance of 47-48, with highest respect to the Central Bureau of Investigation, my lord, Code of Criminal Procedure and the BNSS now also apply to them. But in my understanding as a student of law, they never write 47-48
Hmm.
format, my lord. That's a different story altogether, my lord.
Hmm.
Why I'm saying this, that this time, after we surrendered, my lord, pursuant to the order of the Honorable Apex Court, that I am to surrender because it was default bail was
Default
wrongly
was
granted,
wrongly
my lord.
granted.
We moved the special judge, my lord.
Hmm.
There, my lord, the learned special judge rejected it on the count that he has the same jurisdiction as that of the session judge, my lord. Earlier, my lord, prior to High Court granting bail, my lord.
Hmm.
Have I made my position clear, my lord?
Yes.
And there, 47-48 was taken into consideration.
Hmm.
It was raised, my lord. But the order passed by the session judge, those are
Does
never
not give
taken
it.
into consideration.
Does
And
not.
one authority, my lord, very old,
Hmm.
I should not name the Honorable Judge, Honorable Justice Krishna was there.
Hmm.
Very, my lord, pro-defense, my
Hmm.
lord. In my understanding as a student of law, my lord.
Hmm.
He said, my lord, in any application, subsequent application is good in law, my lord. Subsequent application. And subsequent application can be filed with new grounds, my lord. Have I made my position clear, my lord? So 47-48, and the default part, we have raised it now, my lord. In my application, my lord, can I come to, with all respect, my lord? If she does not dispute whatever I have said, my lord, regarding orders, my lord, have I made my position clear, my lord? Straight away I come to the 47-48 notice, my lord. They occur at page, my lord, with all respect, my lord, page 121, my lord. Hey, hey, tu le do, to be progressed. One 21.
Hmm.
Lordship may have found, my lord.
Yes.
121, same, Taylor made the other one, my lord, that 48 to friends relative, next page, my lord, friends relative or person authorized by the accused, my lord. Have I made my position clear, my lord? Here, my lord, this Prabir Purukaista will be very effective, my lord. There it occurs at para, my lord, with all respect, my lord. What are to be given, because, my lord, the constitutional mandate is this, my lord. As soon as maybe, my lord, 22-1, my lord, grounds of arrest are to be provided, my lord.
Hmm.
Then thereafter, my lord, the legislature thought it fit, my lord, with all respect, my lord, while formulating, my lord, Code of Criminal Procedure, my lord, with all, at that point of time, it was 50 and 50A, my lord,
Hmm.
with all respect, my lord, that, my lord, grounds of arrest are to be provided, my lord, grounds of arrest.
Hmm.
So those grounds of arrest, my lord, there are two things, my lord, the Supreme Court has said, my lord, with all respect, not in so many words,
Hmm.
that grounds of arrest and reasons of arrest. Even reasons of arrest are provided, that would not do, my
Not
lord.
do.
So this piece of paper, my lord, if we peruse it, my lord, prosecution, defense and lordships, my lord, with all respect and full hands, my lord, 121. This is the piece of paper provided. We received it. They're not to talk of grounds of arrest. Even reasons of arrest are not there. If it is apparent, my lord. That kills the entire prosecution story, my lord. And the same is the case 122. To friends, relatives, or person authorized, my lord. 122, my lord. Not to talk of grounds of arrest, and reasons of arrest have not been provided. And this has been clarified by the, my lord, with all respect, my lord. Probir Purukayastha, my lord, para 21, my lord. Oh, no, no. I'm sorry, my lord, para 48. 21 is regarding that in a charge-sheeted case also, my lord, the law would be applicable. Because in Probir Purukayastha, it was a case under Unlawful Activities Prevention Act, so embargo containing section is there. Meaning thereby, even if there is a statutory embargo, even in that event, violation of 47, 48 would be applicable, and those would remain alive, my lord, even after charge sheet has been submitted. Have I made my position clear, my lord? That is apparent in para 21, my lord. Now, my lord, reading 48, with all respect, my lord, may I just, should I, my lord?
Yeah, yes.
With all respect and folded hands, my lord, 48. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. Have I made my position clear, my lord? Grounds of arrest is constitutional mandate and thereafter statutory mandate, my lord. The reasons for arrest as indicated in the arrest memo are purely formal parameters, that is to prevent the accused person from committing any further offense. Goes on and on, my lord. Therefore, grounds of arrest have been defined, my lord. Have I made my position clear?
Yes.
These pieces of paper provided to us, my lord, with all respect, my lord, and we received it in right earnest, my lord, 47 and 47, absolutely bare, my lord. New in the buff, my lord, with all respect, my lord. Nothing is there, my lord. Have I made my position clear, my lord? So this benefit accrues to me, and this cannot be annihilated by the prosecution but in any manner, my lord. And what is their reply, my lord? What is their reply? Let me just read their affidavit, my lord.
Do we have the affidavit on record?
That occurs at, my lord, with all respect and folded hands, my lord, para 153. I'm sorry, my lord, page 153 of their affidavit, my lord.
Was called for, Mr. Mahajan. Would it be convenient if we take it up at 2 again?
My lord,
At 2 again?
my lord, I'm sorry.
Page 153 is what you tried to refer, no?
Their affidavit, my lord, justifying that the notices were served, my lord, 47, 48, despite no content being there, my lord. This is the language, my lord. One line is very important, my lord. I don't know, leaving aside 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th line, my lord. A plain reading of section 47, one of the BNS mandates communication of full particulars of the offense and disjunctive or the grounds of arrest. Have I made my position clear? My lord, CBI cannot create law. They has to go by the law. And there's, my lord, the pieces of paper served on me, devoid of, not to talk of grounds of arrest, even reasons of arrest, my lord. And the reasons of arrest and grounds of arrest, my lord, with all respect, my lord, clarified by the Apex Court in para 48, my lord, with all respect, my lord. This is my case, my lord. And my lord, that statutory thing, my lord, with all default bail, now again it accrues to me, my lord, because it's a 90-day period offense, because I was there in jail
for 60 days.
60 days. Thereafter, after surrender, I am there
another
for 30 days.
Uh.
Again, further investigation is continuing, my lord. Now possibly 193(9), my lord. It again accrues to me, my lord. I get bail on default, and I get bail because of violation of constitutional and statutory rights. With all respect and forgiveness.
We'll come back at 2, man.
My lord.
Well to get. So 47 and 90 days. These are the
Exactly,
two
my lord.
things.
My lord, with all respect and full hands, my lord. Cease to reply only on that, my lord.
Yes, madam.
have confined to a very limited jurisdiction to give reply.
Yeah.
My learned brother. First, I am coming to the fact that my learned brother has already been apprised your lordship that on imposition of the addition of section 409417, so statutory period would be 90 days. Here I have a small submission to this aspect that when the application is pending before the Supreme Court with regard to this issue, at that point of time, 90 days was over. And Supreme Court, Honorable Court, knowing fully well that 90 days is over, however, not granted any relief to that effect. And the judgment is with me, your lordship, for ready reference I am giving.
We have annexed it also.
But I have also taken.
এইটোত পেন এটা আছে মোৰ ভিতৰত মই খুজিছিলো নাহিলে নাই মোৰ লগত
Yes. Supreme Court. I'm giving here for.
This is annexed with our application, my
Yes,
lord.
it is annexed.
Page
with the
87, it begins, my lord, 89 it ends, my lord.
yes
I'm coming with in the paragraph number 3, your lordship. After perusal of the order, it is revealed that the High Court was impressed upon the fact that section 409 of the IPC was already deleted. Hence, it cannot be added by the trial court. In our view, as per the provision of section 358 of the BNSS, because they have taken the plea, why IPC has been imposed, why not BNSS? So that plea has also been taken. Since BNSS is prevailing and IPC has already repealed, that section 409 cannot be imposed. It ought to be BNSS. So that has been clarified here. In our view, as per the provision of section 358(3) of the BNSS, anything done or any action under the IPC shall be deemed to have been done or taken under the corresponding provision of the BNS. It is further to be noted that as per section 187(3)(1) of the Bharatiya Nagarik Suraksha Sanhita, the corresponding provision as of the IPC and CRPC has been as specified has to be reckoned after the commencement of the new act. Therefore, it appears that the High Court has committed an error without considering those provisions in the right earnest. Paragraph number 4, in this view of the matter, it can safely be observed that after addition, the offense under section 409 of the IPC, which is equivalent to section 316(5) of the BNS, the grant of the bail on account of non-filing of the challan within 60 days.
we have read till paragraph 7 yes
Beg your lordship.
we have read it
Yes, it is there.
huh
No, 4. I'm in 4. paragraph.
now I have read till 7 I have read the order. Which part are you
But there's
emphasizing on
no
this one?
problem. So
Yes.
This is clarified.
Hmm.
To this effect, my one reply is that at that point of time, a statutory period of 90 days was over. However, the learned Supreme Court, an Apex Court never entertained that with regard to the bail. And even if it is not refused, but it is in their knowledge, the accused could have praised their prayer in the Supreme Court itself. They have not done it. Best known to them. Thereafter, your lordship, now when this is over, I'm coming with
The
regard
period of 90 days,
to the, is over.
statutory period of 90 days would be over. Now, if we find, if what we are thinking will make it clear to you. The question of releasing him from custody on the expiry of 90 days will arise after he spends 90 days in custody.
Exactly.
So if he is out for whatever purpose, suppose he was given an interim bail to attend some marriage or something, whatever, he was given an interim bail of 5 days. Those 5 days will be added to that 90 days and it will become 95 days.
That is true, your lordship.
So when he did not suffer for 90
He
days,
did not suffer, but at least he could submitted that now charge sheet has been filed and statutory period is over.
could have parties.
Now, to the next point, I am coming with regard to the 47, your lordship.
Hmm.
That is page number 121.
Hmm.
This is notice under section 47 DNSS. But there is a arrest memo is there, ground of arrest memo is very much there. It is in the record
Page,
and,
page.
no, we have brought it from the,
You have filed a, you have filed an objection.
yes, Your Lord.
Where is it in the objection?
In objection, we have said that there is ground of arrest has been given,
Can we refer to this when it is not on record?
but.
If you are drawing support only on this, can we refer to it when it is not on record? If it was a mere passing reference that this is the date and therefore we are referring, to that is a different issue.
Submission is there in page number
Submissions
one.
may be there, ma'am.
Or I.
Yes, what do you say on this?
This is the ground of arrest and clause number 10.
Ah,
Arrest
yes.
This is the format, Your Lordship.
Or this has been rejected by the Supreme Court.
No, it is not rejected.
It has been in other cases. Prevent accused from committing further offense. It is a general reason. Investigation of the case will apply to all cases of arrest. Prevent the accused from causing evidence. We can give you the exact sentences in the judgment, which says that these are all reasons applicable to any person being arrested. And the difference with the ground of arrest is it has to be personal to that person with regard to that particular case. This much of contraband is found on your person, therefore you are under arrest, sir, because we now need to investigate.
Then Your Lordship.
Let us have that,
then
that
Your
old
Lordship,
judgment. What is-
at this stage, I may be permitted some
Nothing
time
doing, he's-
so that I can bring.
He's
the certified
inside.
Copy.
He's inside.
But.
He is
but I-
inside. Your unpreparedness is not keeping anybody behind bars. I'm sorry.
No, but the ground has been given, Your Lordship.
Yes, that ground has not been given.
Ground
That
has
is
been
not the
given.
ground required to be given. Let us read, where was it? Probi Purkayastha it was said. Where-
Yeah,
that,
para
those
48.
exact sentences.
I'm sorry, my lord.
That
37,
exact
madam.
sentence.
And that has been diluted in Sri Darshan's cases and subsequently in Mihir Shah case.
Mihir Shah,
Recently, yes.
Mihir Shah
Has been released.
you give him the appropriate grounds of arrest, you arrest him again and give him the appropriate ground of arrest. That is what Mihir Shah says.
No, that is there.
Once we find that the grounds of arrest were not given to him, he is entitled. The moment he is entitled, now your entitlement starts. Arrest him again, give him the proper grounds of arrest. Finish it. Why prolong it? That is the only thing we want to know.
Has been given along
No,
with this.
for your
to the
satisfaction, we
other
will-
factors also.
Para
For your-
27, madam.
For your satisfaction, we will just go through it again. 37, no, not 37, that the difference which was drawn,
48, my lord.
para 48.
48.
Yes, kindly come, do you have this copy, madam?
Which one, Your Lordship?
Prabir Purkayastha?
No, I have Sri Darshan.
No, please have Prabir Purkayastha for a moment, or
Because
Let us see.
subsequently Sri Darshan has come, wherein it is averred that in the serious offences, it can be exempted.
our understanding of the law is Prabir Purkayastha cannot be overridden.
Good law.
It has not been overridden till now.
But Sri Darshan has come subsequently.
What does Sri Darshan say?
No,
What is the what is the dilution?
Of the Pravir Purkayastha and Bansal has also been referred here.
Please tell us.
Coming to that.
We are running a little short of time, so we have to also hurry up.
It's a big judgment, Your Lordship.
Please show us. Very happy to see.
Pravir Purkayastha. Pankaj Bansal and here.
Huh?
In paragraph number 21.6, The High Court, however, relied heavily on the alleged procedural lapses as determinative factor while overlooking the gravity of the offense under section 302 of the IPC and the existence of the prima facie case. I noted inter alia that there was no mention in the remand order about the service of memo of ground of arrest para 45. The arrest memo were allegedly templated based on not personalized. An eyewitness had not stated that they were present at the time of arrest, had signed the memos, relying on the Pankaj Bansal so and so, that from 30/10/23 onward, failure to serve the detail written and individual ground of arrest immediately after the arrest was violative entitled to accused on bail. In the present case, the arrest memo and the remand records clearly reflect that the respondent were aware of the reason of their arrest. They were legally represented from the OSC and applied for bail shortly after arrest, evidencing an immediate and informed understanding of the accusation. No material has been placed on record to establish any prejudice was caused due to the alleged procedural lapses in the absence of demonstrable prejudice, such as irregularity, at best the curable defect and cannot by itself warrant release on bail. As reiterated above, the High Court treated it as a determinative factor while overlooking the gravity of the charge under section 302 IPC and the existence of prima facie case. It reliance on Pankaj Bansal and Pravir Purkayastha is misplaced. It is there. As those decisions turn on materially different factor and statutory context, the approach adopted here is inconsistent with the settled principle of procedural lapses in furnishing ground of arrest. Absent prejudice do not ipso facto render custodial illegal or illegal the
Now
accused.
kindly tell us that in the arrest memo was given to him.
Yes, sir. His
Arrest memo.
signature is there.
Yes, now in the arrest memo, when a person reads the arrest memo, tell us what would he state for while filing his bail application.
Beg your lordship.
He has to read the arrest memo and make the further submissions in the court that this is why I want bail.
Yes,
Yes.
that is also there. It is in the record. If the record is
Where is it in the arrest memo?
one
From
forward-
committing any further offense. So this arrest memo says from committing any further offense. It does not relate to the offense and for which he has been arrested. Am I correct? It tells him that we are doing it so that he does not commit any further offense. It says that it is for proper investigation of the offense. Show us where is the offense?
In the record, there is a one forwarding note of the arrested person in the state. police.
Forwarding note,
Yes, that is given by the
that was
state police.
that was written by the arrested person.
No, that is by the IO,
Then
wherein the grounds has been given.
the
Ground is
grounds
here.
are required to be given in the notice which is given to him, which you depend upon to say that this is a notice. This is the notice, is the sentence we want. This is the notice, which we find at 121. You are saying you are informed that you are under arrest in connection with the above reference
Yes,
case.
yes, your lordship.
Case is non-bailable to police. You are forwarded to jail custody. You may submit petition before the court for bail.
So this is there. There are two parts. It is in the because.
Where
that
is it?
why-
Show us the record, where is it? Ask her to flag it.
Because charge sheet has been filed and it is there. This paper is, I am holding this paper and the ground of arrest is given. Those are enclosed.
47.
Background of the case is also given. This is-
47 we have considered, and the other part, the 90-day part also you have argued. Anything more? Diyo ki bakang bilis.
And all annexures, enclosures are given, the detail of the enclosure.
Please. Arrest memo, yes, we have seen the arrest memo. Inspection memo was given to the judge. Intimation under 47 BNSS, this is the one.
This is the one and.
This is the one that page 121.
And in the first
And-
page of the ground of arrest
And
has been,
medical-
detail of the ground of arrest has been given.
Yes. 5 is again the general ground.
Yes, Your Lordship.
6 is general ground. 4 is a general ground.
No, Lordship, the
3 to some extent,
pages just now I have given
I'm reading that.
containing 2 pages.
I'm reading
Yes,
that only.
yes.
Arrested accused was involved in the instant case reference. Arrested accused is an FIR named accused person. Okay,
And these are very much in the lower court's record, probably which has, a scanned copy has already been called for, Your Lordship.
and the court would be lesser burden if in the morning when this record was available, the relevant pages could have been marked by the councils.
But this
Would
is being
depend upon the-
requisition from the court itself. It
Yes,
is
it
not.
was here in the record. With one permission, you can flag it. Every case diary is flagged by the PPs with the relevant pages they want to depend upon. If you expect us to go through all this to find out which particular document you are depending upon, madam.
It is annexed with the charge sheet, Your Lordship.
Huh?
Charge sheet.
Yes, we'll have to pass the orders in the chamber because we'll have to open up the entire file,
And
trace out the charge sheet.
we have brought the CD also, Your Lordship. CD is there. I have already flagged marked. Why we are opposing this? Because further investigation is going on and Ranjit Kakoti was the nominee of the company. To that effect, their resolution, board resolution is there. And Jitendra is the director of the
He was
company.
initially arrested on
Initially, yes, my lord, with all respect.
Arrested on 3994, Your Lordship.
Exactly.
2024. He was arrested in 2024. 1 year and 2 months gone.
After surrender, yes.
Charge sheet has been submitted. After the charge sheet, what further investigation are you pointing towards?
Why? Because he is the nominee and the director of the company, they are not cooperating with the investigating agency.
So the nominee is to be punished.
He is making the all promoters work.
He's inside bars. How is he
taking
doing
the-
it?
No, earlier he has done. And if
Yes.
he will be released on bail, there is every likelihood that he will temper the evidences and the documents.
Which-
That I,
Which you have already collected and submitted to the court.
for others, Jitendra, who is the
Which are
director, there are 4 directors.
rightly
I'm
questioning.
coming to that fact. Jitendra, it is in the PMLA court also, Your Lordship. That is a Jitendra, Mr. Jitendra and Mr. Biswajit Kuwar and Ranjit Kakoti and Chinku Basumatari. They are not cooperating. They are still avoiding. Another complaint case is also there in the PMLA. Ye de dijiye. It is already there in the Delhi. And moreover, this all Ponzi cases has been transferred to the CBI by the order of the Honorable Apex Court. And thereafter, this case has also been registered and they are not cooperating. Jitendra is the director of this company. Biswajit Kuwar, Ranjit Kakoti, Tinku Basumatari. I have already marked in the second page, Your Lordship.
Ranjit Kakoti is before us.
Yes, Your Lordship.
He's
And now.
he is in custody, so the question of
Are evading.
so the question of Ranjit Kakoti not cooperating with the investigation would not arise at this point of
At
time.
this
He is
point.
with you.
But there is every likelihood that.
He will influence the others.
Yes.
Okay. We'll
Because
pass the orders in the
it's
chamber.
Still the investigation is going on
Hmm.
and they are not appearing. Jitendra, Biswajit and Chinku Basumatari, they are not appearing.
Look, may I just add one line? my lord?
Yes.
My lord, regarding that 90-day period, my lord, the Guwahati High Court authority is, my lord, with all respect, my lord, the, my lord, Sami rule. Samu rule is based on an apex court
Justice
authority.
Kalita's order.
My lord,
Justice Kalita's order.
exactly, my lord. Sami rule, my lord, Samu rule is
Part
based on
charge sheet
the,
will not.
my lord.
Part charge sheet.
Yeah, exactly, my lord. My lord, here, my lord, let me just read one line of the charge sheet and the Sami rule is based on the apex court authority, my lord. And apex court was challenged by CBI and apex court okayed it, my lord.
Which part of the charge sheet you would like to
Exactly,
read?
my lord. That occurs at, my lord, with all respect, my lord. So
Have you
again,
given-
default, my lord.
Have you Annex the charge sheet, yes.
Yes, yes,
Final report, yes.
very much. 76, my lord.
Just beyond the case we are saying,
Yes, ma'am.
we saw an underlining here
Yes,
regarding a certain amount of money
my lord.
that would take us many days to count.
My lord, huge money, my lord. Yes, my lord. Your lordship is very correct. Here, two lines are important, my lord. 16.41. The further investigation of the case in page 76, my lord.
Page 76.
Annexed with the application. Page 76, copy of charge sheet, my lord. The further, leaving aside two paragraphs from the top, my lord. 16.48. Lordship may have found, my lord. The further investigation of the case in the interest of justice will continue under section 193(9), earlier 173(8), my lord. And the last parting line, my lord, 16.49. Investigation in respect of AI Ranjit Kakoti, the present accused before your lordships, has been completed. Supplementary final report under section 199 BNSS will be submitted, meaning thereby further investigation is on, my lord. Have I made my position clear, my lord? Now, my lord, Samirul is based on Sabaria, my lord. The lordship knows, my lord, that's just one line, my lord. There, my lord, that Sabaria authority, my lord, with all respect, my lord. Para 33, my lord. It is video. (28) and 33, 23 I am not reading, my lord. 33, the ratio part of it, my lord. Lordship may have found, my lord. The view above mentioned discussion, the issue framed by us then answered as under. Without completing the investigation of a case, a charge sheet or prosecution complaint, here it is a charge sheet, my lord, cannot be filed by an investigating agency only to deprive an arrested accused of his right to default bail under section 167(2), now 187. Now 187. It was challenged, my lord, by way of a review petition. Review has been dismissed, my lord, by the apex court, my lord.
Yes, any finding in any of your reports that during that time when he was on an erroneous default bail, he had committed any act which should hamper or tamper with the investigation? Anywhere you have made a statement there that during this period of time when he was on bail, the investigation was hampered or the witnesses were tampered, which has led to the delay in the investigation? No.
But the delay is causing because
Presumptions,
Jitendra
madam.
is not appearing.
Jitendra
Directors are not appearing.
Very well.
That is one of the reason. They are not
There
appearing.
are provisions of law to deal with that, but when it is not even your stand that when the time he was not behind bars, he did nothing. If you had said that he was hampering and tempering everything at that point of time,
My lord.
some statement by your investigating agency, not there.
Okay, but civil.
Yes, next, we'll dispose it of in the
All right.
chamber. We are granting the bail. We'll put
But
on the
with
conditions.
regard to the parity, I have a certain submission
Huh?
and the judgment also with regard to the parity.
Parity of what?
Parity cannot be granted if
To
somebody.
whom? With whom is he asking parity?
I thought he is asking for some parity of that.
With whom?
And with regard to the economic offenses,
Yes, madam.
I have the
Or
judgment.
we can do one thing, we can, if you want to prolong the arguments, we can give him the interim bail and we'll keep it for February, we can
No,
hear you
it's-
further.
Kindly,
We'll
kindly.
dispose it of today, either this way or that. Yes, thank you.
It can be reserved, your
Okay.
lordship. But I have the judgment if your lordship were willing to.
Please, submit whatever.
I can submit.
We will we'll have it considered in the orders.
I give it everything.
This next to madam. Madam, you can take your time, let the others come. Give the judgments. Huh? নহয় যিকেইটা ৰেগুলাৰ চলি আছে প্ৰডাকশ্যনটো কি মোচন আৰু মোচনটো নাই বেলেগ আৰুটো নাই বেলেগ এইটো প্ৰথম এইটো মোচন নহয় জানো প্ৰডাকশ্যন লিষ্টত মোচনত আহিছে আৰু মোচনটো আগতে নাছিল
Console list. Item one.
Yes, sir. Chamber did order.
My lord, this is
Ah.
a disputed bail, my lord.
Ah.
The petitioner as well as the informant
Ah.
are the very close friend.
Ah.
But there was a dispute regarding a transaction of money of rupees 1,50,000. The the informant borrowed 1,50,000 from the petitioner. But on the date of occurrence, a quarrel was taken place in the shop of the informant, a jewelry shop. And the petitioner was forcefully driven out from his shop and grill was closed. And the informant gunshot to the petitioner, two gunshot in his chest, my lord, he is hospitalized. Till now he is under treatment. 2 operation is done, my lord. I have annexed the medical document. My lord, on the other hand, the informant filed an instant FIR, my lord, false FIR, my lord, on the date of occurrence, my lord, saying that my lord, the pistol was in the hand of the petitioner. If the pistol was in the hand of the petitioner, then who has gunshot to
We
the
are not
informant?
going into that.
My lord,
You
the-
have approached this court on an urgent basis that
My lord.
since you are undergoing treatment
treatment, my lord.
with regard to this hospital thing,
My lord.
with this gunshot thing, that is
My
why
lord.
we have given you the
Lordship-
opportunity. We will, till the surgical procedures are over and the doctors declare him fit,
My lord.
He has already undergone.
he has underwent, so now the investigating authority can ask the doctors if he's fit enough. Till the
Yes.
time he's declared fit to be taken into custody, gunshot wounds may require some time.
Yeah, it may require some time.
If we allow you to take him into custody, it will be your headache. Think about it.
My lord, my prayer is that, my lord, Lord may examine the whole matter, my lord, till
Ah.
then I may be protected, my lord.
When? Till when?
Till, my lord, Lordship may examine the matter, CD may be called for, my lord.
Ah.
I have annexed both the FIR. One FIR is lodged by us, that is not registered, no action has been taken. One FIR, my lord, against us is registered. So, my lord, Lordship may examine the whole matter, my lord, CD may be called for. In the meantime, my lord, I may be protected, my lord, because I am in the hospital, my lord.
He is current, if you have page 20 for a moment,
Yes, I have
page
seen-
20, he is admitted in the hospital. Let
yes,
him,
yes.
if he is on, if he is not,
The thing is, Lordship, he was admitted on 2nd.
6/12.
Yes, and by this certificate is seen, Lordship, that already
He is
Surgery
currently
has been done.
admitted in the hospital.
surgery has been done. So if Lordship fixes a date in the next week, we can produce the case diary because apparently the gun was his. And the story which he is projecting differs from the story that is projected in the FIR. Because it seems Lordship he was the aggressor and somehow because of some scuffle, the injury took place. In any case, he's injured, Lordship, that is admitted.
When he is admitted in the hospital to ensure his participation in the trial,
Lordship, that would be,
if we allow him the interim bail, he will have to deposit something with you. He will have to have a surety or a bond.
yes,
By the time the CD comes,
yes,
we see that something leads against him, we'll consider it on that day.
Lordship,
But in the meantime,
Lordship. Then in the,
if you have to arrest him, the entire responsibility of the treatment will then shift to your shoulders.
then may I suggest one thing,
Ah.
Lordship? Lordship will fix a date in the next week. We'll see the materials in the case diary, if it warrants his custody interrogation.
Ah.
Till then that, if Lordship is.
Till the, we are only saying till the medical part is over,
And in the
not
meantime-
further than that.
in the
Otherwise,
meantime, he can also produce some medical certificate. Because maybe by that time he may have recovered, Lordship, to the extent of what was the injury that was caused, because.
where were you shot? Legs?
My lord, no, chest, my lord.
Where is the,
Chest, my lord, I have, my lord, page number 18 is the.
page number 18?
18 is the vernacular FIR lodged
That
by my
is the
wife, my
FIR,
lord.
Lordship, that is.
Lodged by my wife, my lord.
No, with the gunshot wound, you have only page 20.
Yes,
My lord.
yes. that
Why
is-
only page 20? There must be some record of the,
Yes.
not given to
Surgical,
you.
Page number 20 is the.
That is a certificate.
My lord.
Only gunshot injury is mentioned, but where, what surgical injury, there has to be some medical document. What was the type of surgery he underwent, Lordship? Let him
On the
produce,
date of hearing, I will produce all the medical, my lord.
let him produce all those
My lord,
documents
yes,
in the
all
next
the
date
medical.
fixed, Lordship.
The seat number, bed number, my lord, I have, my lord, categorically stated. and
Jewelry
doctor-
shop is whose? Yours or the other one?
Informants.
Informant.
My-
Your husband was outside
Yes, my lord.
after closing the gate.
Yes,
And the other man shot from the inside.
my lord.
But
And the
story in the FIR is
informant
somewhat
find out the
different.
pistol from the box, my lord. After finding from the box, my lord, my lord, he has shot, my lord, to me, my lord.
Heard Mr. Swenson learned counsel petition, learned counsel appearing for the petitioner, also heard Mr. Sharma learned APP. The learned counsel for the petitioner has submitted that due to the injuries suffered due to gunshot. Now, due to the gunshot injuries suffered by the petitioner in connection with the incidents referred to in the FIR dated 4/12/2025, which has culminated in Kharupetia PS case number 137 of 2025, the petitioner is undergoing treatment at the Apollo Hospital, Boragaon, and has undergone surgical intervention on 2/12/2025. Full stop. The learned counsel for the petitioner has submitted that since the petitioner is under hospitalization, the prayer for pre-arrest bail may be considered so that the treatment is not hampered. Full stop. Learned APP has objected to the aforesaid bail petition, aforesaid prayer by submitting that the contents of the FIR indicate that the petitioner was involved in the incident, and in fact the gun from which he was wounded was also of belonging to the petitioner. Full stop. He has therefore submitted that at this point of time, the prayer for pre-arrest bail does not deserve consideration of the court. Full stop. We have heard the submission, we have heard the learned counsel appearing for the contesting parties. Full stop. In the view of this court, the petitioner is required to undergo the treatment as per the certificate issued at so-and-so, therefore, full stop, call for the case diary, full stop. It is provided that before the next, in case the petitioner is arrested before the next date of listing, he shall be released on punishing a bond of rupees 25,000 with a surety of the like amount subject to the satisfaction of the investigating authority. Full stop. It is, however, provided that in case the investigating authority finds that the petitioner does not require hospitalization or other specialized care, the same may be informed to this court on the next date of listing. Full stop. List again on 19th or 18th, 19th, on 19th of December 2025, on which day the learned APP will produce the case diary. Yes.
Was it just one thing?
He
is stating that Lordship, the revolver is not his and it was taken out from a box of the shop. Whereas in the FIR, it is stated that he was the person who took the revolver out of his waist. So that
All
was-
these things you investigate. All we are saying is there is no stopping to any investigation part. Only thing is, if you need to arrest him in the meantime, do not take him out of the hospital, allow him to remain there, and therefore we have said that he will furnish the bond. Continue your investigation on the next day, tell us on a piece of document that the doctor says his hospitalization is not required.
Lordship.
If required, we'll reconsider the interim. There are instances where we have recalled the interim bail. Are there not?
Lordship.
For the time being, let him be treated in peace
Lordship.
so that he can face the trial
Lordship.
with agony. Yes.
Item 28.
Yes, anything else, Mr. Ali? You wanted anything else?
Here in this case, Lordship, the petitioner is in custody for last 46 days,
Huh?
intermediate quantity, Lordship. And initial information was that one Imadul Islam, who is a drug peddler, has stored some contraband in his house. Accordingly, police went to his house and recovered the contraband. The petitioner was in his house to see his bedridden mother, Lordship. So police now said that it was recovered from his possession. So
No, we did not understand.
this present petitioner was in the house of Imadul Islam. Lordship.
Ah,
That police got information that Imadul Islam is dealing with narcotic contraband. Accordingly, went to his house and recovered some contraband. Now in the FIR, it is
along
said-
with the petitioner
No,
who was
he
inside
was-
the.
He was absconding. He was not found.
Oh,
So subsequently, they said that these contrabands were recovered from his possession. So this is a matter of trial. Then you will face the trial. So already 46 days in custody. And quantity is, Lordship, 4 kg and commercial quantity is 20 kg. Ganja was recovered.
yes, sir.
Yes, Lordship, FSL report not received yet, Lordship, and statement of the apprehended person, it came to light that the apprehended persons are involved in drug trafficking since a long time, along with the associate, namely Imdadul Islam and Mirazul Islam also.
Hmm.
And an apprehended persons is an organized gang which is involved in illegal procuring the NDPS substance from the refined place to causing harm to the society, Lordship. Recovery has made from her possession, Lordship.
When arrested, 2110.
Lordship. As on today, 46.
FSL report not received yet.
Let us await the FOCL report.
Also consider the detention period.
Huh?
Detention period. Lordship. At this, I am not on merit of the case because mandatory period is 60 days.
Hmm.
Only 14 days.
By 19th, can we try? 17th, 19th, whatever you see.
17th. Lordship.
17th. The Learned APP submits that the FSL report is awaited, full stop. List the matter again on 17/12/2025. The Learned Counsel for the petition has submitted it as of today. The petitioner has already suffered 46 days of incarceration, whereas the statutory period is
60 days.
60 days.
How long?
17 দিলো 17 লিখেছে না 17-12 লিখেছে
Item 9.
Item 9. Yes, sir.
Pardon, my lord.
Mhm.
The FIR is at page 10, my lord.
Hmm.
ये मतलब तो non-bailable section 67A of the IT Act, my lord.
Huh?
The only non-bailable section 67A of the IT Act, my lord.
Hmm.
Maximum punishment is 5 years, my lord.
Hmm.
So my humble prayer is that normally, my lord, 41 days resorted to, my lord.
Hmm?
Normally 41 days, now 35(3), my lord,
Hmm.
is resorted to, my lord. Lordship, can you come to page 16, my lord? The remand order, my lord.
Hmm.
Page 16, my lord.
Hmm.
Lordship reads the entire order, my lord. There is no appreciation or observation that 35(3) was not necessary, my lord. And that is a must, my lord. As per Satendra Kumar until, my lord. That itself vitiates my arrest, my lord. When I'm
Sorry, 35 will vitiate the arrest.
Yes, my lord, because if the learned court below, my lord, while remanding me, is not satisfied, or there is no satisfaction on the face of the record, that 35(3) was not needed, my lord. That would be an incurable defect, my lord. In this order, my lord, there is nothing, my lord. And as per until, my lord, every court, my lord, at the time of remand, my lord, has to satisfy itself as to why 41A, that time, my lord, was not resorted to, my lord. And if there is any non-compliance, my lord, bail should be granted, my lord. I brought the judgment as well, my lord.
When were you arrested? 5/12.
5/12, my lord. I'm not 22 years of age, my lord.
Huh?
22 years of age, my lord. So, Mr.
Yes, sir. What do you say? 35(3), what do you say?
Lordship, 35(3), Lordship, it is not like that, Lordship, in each and every case, Lordship, persons who are, who have been accused of below 7 years punishment, he will be allowed to go on bail by giving him some notice or 35(3) notice, Lordship. Because, Lordship, in some cases, if the language is that, Lordship, if his arrest is not required, then he will be allowed to go on, go by giving him the notice, 35(3) notice, Lordship. As what Anesh Kumar and Satyendra until says, Lordship. And if he is being arrested, that his arrest is required, then he will be sent. He will be sent along with a checklist. That why he has been arrested. Ground everything is there, Lordship. A checklist is to be prepared. That in Anesh Kumar case, Lordship, that has been clarified, Lordship. So, Lordship, here in this case, Lordship, we do not know whether that checklist is being given or not, Lordship. That will come only after, Lordship, the production of the CD, Lordship, along with CD, Lordship.
No, my submission is not that, my lord, without giving 41A or not 35(3), person can be arrested, my lord. Person can definitely be arrested, my lord.
But the
Earlier,
learned court has to look into
the
whether.
has to look into it, my lord. It is the Honorable Supreme Court, my lord, may I please the judgment, only one line, my lord.
Plus.
She will turn to page 15, my lord, of the, that is the forwarding report, my lord.
Hmm?
Page 15, my lord,
Of?
of the petition, my lord, the forwarding report, my lord. What she will see, point number 5, 6, 7, my lord.
Ah. Yes.
This is earlier, my lord, the reasons of arrest, my lord, in 41, my lord. My lordship will come to, my lord, para 29 of the until, my lord.
Yes.
But despite the dictum of this court in Anesh Kumar so and so, no concrete step has been taken to comply with the mandate of section 41A of the code. This court has clearly interpreted sections 41(1)(b), 1 and Roman 2 inter alia, holding that notwithstanding the existence of a reason to believe, who are a police officer, the satisfaction for the need to arrest will also be present. Thus, subclause 1(b)(1), Roman 1 of section 41 has to be read along with subclause Roman 2. Therefore, both the elements of reason to believe and satisfaction qua an arrest are mandated and accordingly are to be recorded by the police officer. That is what my learned senior is saying regarding the checklist, my lord. That is there, my lord. However, my lord, we should come to the conclusion part, my lord. That is paragraph 100.3, my lord. Yes, my lord. The courts will have to satisfy themselves on the compliance of section 41 and 41 capital A of the code. Any non-compliance will entitle the accused for grant of bail, my lord. Here, my lord, the remand order, my lord, is completely silent as regards 40.
No, any compliance, any non-compliance of 41A
Yes, my lord.
or 41, that will vitiate the arrest.
Now the learned magistrate, my lord, has to record its
It
satisfaction.
does not say that if the courts do not satisfy, then the accused will be entitled to grant.
No, madam,
It
how much
says
is the-
that the courts have to satisfy. And if the court finds that 41 or 41A was not complied, then the entitlement to bail will follow. Therefore, they have to satisfy themselves.
Yes, my lord, but
So
that
that
has to be-
satisfaction needs to be recorded or that satisfaction has
it
to be
recorded,
negated.
my lord. It has to be recorded, my lord.
What was that?
It cannot be mechanical, my lord. That is what the judgment says, my lord.
It's a mechanical. If it finds that it is
Because, my
satisfied.
lord, what you will kindly see the order, my lord, page 16. It only talks about 47 and 40 of the BNS, my lord. It only talks about section 47 and 40 of the BNS, my lord. There is nothing regarding 35(1) and 35(3), my lord. That yes, he would flee away. He has previous cases. He would jump bail. Nothing of that sort, my lord. This is his first case, my lord. 22 years of
When
age.
can you have the CD, sir?
Lordship. Immediately after opening. Immediately after opening.
Kindly, Lord Lordship, kindly, my lord. I'm 22 years of age, my lord. Yes, Mr. Malama. Some mistake here and there, my lord. It is not that I'm a direct criminal, my lord.
Yes, my Lordship, his act is like that. Lordship may kindly come to page 14, para 3, Lordship. The last line, Lordship, he not only did again, in case of this girl, Lordship, some other girl's nude photo has been published here, Lordship.
No.
That is Neha Sharma or like that, Neha Sohan. So this is his regular activities, Lordship.
No, my lord.
Earlier, this is the once he did.
A coconut in a monkey's hand. He does not know what to do with it. He has got the internet, he has got a phone. He does not know what to do with it.
Kindly,
The vacation also not possible. We'll have it on the fifth, sixth.
kindly before
Earliest.
vacation, my lord.
Huh?
Kindly before vacation, my lord.
We are,
Well, let it be on 18th, my lord, because unnecessary is inside, my lord.
huh?
No, unnecessarily, we cannot say Lordship. He is
My lord,
active.
He has,
Unnecessarily not.
he has done something that is not,
Necessarily some.
but it is not that he should be put behind bars, my lord.
Huh?
It is not that he
One
should put
card,
behind
we
bars
have
for
to
a
see
prolonged
the,
period.
what is the present status of the present mind status of the
My
card.
phone
Lordship.
has been seized. It is not that I can access my phone now, my lord.
Huh?
My phone has been seized, my lord. It has been sent for FSL or by the police, my lord.
1200 rupees they are available in the market. Is sixth we can have it.
Kindly before vacation, my
Eighth.
lord. Any date, my lord.
Okay, by 19th can you? 19th. Call for the CD administrator Mahajan. 19th of কি দিছে?
Oblige, my lord. Highly
মই জানুৱাৰী হলে কৈ দিম।
That please, your lordship.
Yes, sir. Do you have the instruction?
Lordship, I have directed to produce the case diary, I have obtained the case diary.
No,
All compliance has been made. And
Who was informed?
Lordship,
In his family, who was informed?
father lords,
Father was informed.
yes, lord,
And when?
on the same day, over telephone. He is residing in Bihar. Lordship, please to,
So now how many days have gone from the arrest?
Lordship,
How many days after the arrest now?
on the same day.
No, how many days have gone from the arrest now?
Lordship, he was arrested on 23/6/2025.
Thereafter, has the family been given the written
Yes, Lord. It was
communication when?
sent through the police
When?
on 24/6/25 through email.
They received it on 24/6
See,
or the
because-
police received it?
Police received email on same day.
When did they receive it? The
Lordship,
family and the friends?
That we don't have information.
Then it goes. You had the option of having it received in the family.
Lordship, they are residing in Bihar.
Yes, you could send it to Bihar police.
Yes,
You could
Lordship,
have
it was
ensured
sent.
it.
Lordship, please to Peru's case diary. It is there.
No, it was sent to Bihar police. Thereafter what?
Lordship, thereafter, Lordship, we have not any information.
You have
Because
not taken the pain to
investigation.
find out whether it has been delivered to the father or not.
That Lordship may fixed on Monday, Lordship,
What?
I'll obtain instruction whether it has been delivered, if they have received any document. This is a document through which the father was intimated. And Lordship, next page is that on the same day he was.
So and
informed through
so.
telephone.
This was sent by the,
It was handed over to the accused person, Lordship, on the same.
this was handed over to the accused person. Very well, then,
And it, on the same day, the telephone number provided by the accused person, his father was informed.
Brother, in the objection, they said, lordship, brother was telephonically informed.
that is what that is why we were keeping silent, you are opening your mouth. Yes, brother or father, who?
Lordship, it is, from the record, it is, Lordship, because,
Huh?
in the intimation, it is written that his brother was informed. In the written instruction. And the letter sent to the father laws.
All confused.
The contraband
There
was,
is no, nothing on the record to show that the family had received the written instructions
that Lordship.
immediately after the arrest.
Lordship, when they are residing outside the
Very well.
state,
What steps were taken after sending of the email to the Bihar police? Nothing here.
Lordship, that I have to.
Monday you want it.
Lordship, Monday.
Monday, we'll finish it. At the request of Mr. SCKL, list this case again on Monday. So that to inform this court whether any steps had been taken to inform the family of the arrested person regarding his arrest. We'll keep the sentence at that, come up with everything again.
Lord,
এখন ঘূৰাই দি দিব ৰেকৰ্ডটো, য়েছ।
He can.
দিয়ক অলপ কুইক, হা? কেইটাত উঠিব দিছে, 3:15 নে 3:15 ন? Yes,
Here in this case, probably your lordship remember that I have raised the issue that he was initially taken in the intervening night of 5th and 6th by the police. Thereafter, he was detained. Police made investigation. And more than 24 hours he was kept in police custody and he was produced after 36 hours. So I
yes,
have just given the short dates, lordship, that lordship can have a look. Lordship.
yes.
And just lordship may remember that one report is there. Report says lordship, that report is in the record lordship. Lordship can see that he was picked up on the
Mr. Goswami,
Yes, Lordship.
just contradict us if this statement is wrong
Yes.
from your records, whatever you have.
Only the
Information received on 12:30 AM 6/7,
as per FIR.
Hmm?
As per FIR.
as per the FIR. As per the report submitted by investigating officer, accused was brought at 3:30 AM on 6/7 itself.
Yes, Lordship.
Hmm?
Yes.
Then seizure, as per seizure list, seizure is made on 6/7.
At
Report of
11:37
IO says contraband on 7/7. What is the quantity?
Quantity is lordship 2000, approx 2000 yaba tablet.
Hmm? After some time? You want to
Lordship,
go through
only-
this?
Only we have the information that's partially submitted in this case.
Charge sheet has
Sir,
been
submitted.
submitted, huh?
But probably your lordship remember, there was a order for retaining the case diary. They have taken back the case diary. Then they said they will obtain the CD lordship pro scan copy. Now they are saying lordship that this is.
Charge sheet,
Lordship may kindly have a look at page 59 lordship. This is their arrest memo. They admittedly said lordship that he was arrested on 7/7/2025 at 1:30 PM. And as per Mihir Rajesh Shah lordship, that those memo has to be given prior to 2 hours. So that after 3:30 he was produced. So if that is so, lordship, apparently 36 hours is there, lordship. So lordship may consider this. I'm just having gone before judgment that I have already placed before lordship. Again, I'm giving it copy, lordship.
this one, this Directorate of Enforcement versus Subhash Sharma.
Yes, that exactly covers my case.
Yes, Mr. Goswami.
Yes, Lordship, here also Shastri already submitted, we have not a record here, Lordship. Is there a send back in it? So,
On the understanding that the updated case diary would come.
yes. Along with the records also.
And if I can show from the record that violation of article is there, constitutional right is there, then I cannot be kept behind for a second. Lordship. That is what Bihan Kumar says.
So give a last chance to go through the records for Lordship, then.
Huh?
Give us
Interim
a last chance to go through the
When?
records.
Then interim may be granted, Lordship, because I am not relying on any dispute.
Records when? Last chance to go through records when? Today, the Monday?
The records is not here. Shastri submitted to corporate records and we have to go through the records. Lordship will go through the records and records will reveal everything, Lordship, then Lordship will consider.
In that case, I am praying for interim order, Lordship, because I am not relying on any disputed documents, Lordship. All the documents certified copy, they produced by them only. All these documents. I have not produced any documents from my side, Lordship. And it is apparent that I was produced after 36 hours. In that case,
Yes.
interim may be done.
Production after 36 hours is what is not troubling us. The attempt. The overwriting on the dates. There are overwritings on the date.
Lordship.
So
That's why Lordship.
come for question. You come for cancellation of bail, he again indulges, you come back.
At least for our submission, make our submission.
Your vehement objection along with your request to go through the records once again, everything will be considered. There is no worry to that. But in the given circumstances, with the overwriting, the 24 hours period being exceeded, everything adds up to
Lordship.
non-compliance of the happens in 1 or 2 cases, cannot be helped. We'll allow it. Next, huh? Dispose. We pass on order. Once the meeting is over, we pass on, huh? 55, 57, কেইটামান থাকি গ'ল?
May I please, Malad?
Yes.
There are 3 bail applications, my lord. I am appearing in 55 and 56. These 2 are the teachers of the school. He is 57, he is the headmaster, my lord. Allegation is that, my lord, Lordship may kindly come to FIR, my lord, page 12. 55.
Respondent appearing?
Yes,
Ah, yes, you are appearing for the, huh?
I'm the mother of my daughter studied in Swiss.
Yes, tell us.
Page 12 is the FIR. Allegation is against one Bhikkhu Chetri, my lord. He is also one of the teachers of the school. Allegation is that he has raped the victim girl and he has recorded her video. And thereafter, my lord, she has consumed phenyl.
January?
My lord.
January 8th,
My lord.
awaiting instructions by the PP. Short কৈ গৈছো, short লিখি যাওক, পিছত elaborate কৰি থাকিম ওটাৰ ভিতৰত। দিয়ক আৰু দুখন ল'ব পাৰিম চাগে।
6.
IS civil for what? Condoning of delay and request for the petitioner on call list again on 6 তাৰিখে দি দিয়ক। 6 January. এইটো লাষ্ট নে আৰু আছে? Any more? ইয়াৰ পিছতো আছে নেকি? এটা। Yes, 48.
We are in interim, Your Lordship.
You are on interim.
Yes, sir. Thank you.
Yes. Since the court has to rise at 3:15 for a reference, list this matter again on 27th of January 2026. Full stop. Interim orders passed earlier shall continue. Yes.
Deeply.
আৰু কি থাকি গ'ল?
47.
47. None appears for the petitioners on call. List this matter again on 2nd of February 2026 for consideration. Huh? Keep. Huh? How good?
Yeah, please, Your Lordship.
Yes.
Item number 43, we have agreed for 20th January.
Lordship, 20th January in that case.
20.
Response have some
Huh?
difficulty on 18th, Lordship.
You wanted it on Thursday next.
Lordship, but respondents have some difficulty, Lordship.
So we have
If
agreed.
it is a modification, it is up to us to modify or not to modify. What? Is it not?
Don't be there. I may not be there. That is why.
Okay. Huh? 20 January.
20th January. They
January.
agreed. Earlier they told me 20th January somehow.
It's all right.
Much of.
Thank you.
Deeply obliged, my lord.